Hi, I'm Professor John Delaney. I'm now retired, but I taught at the New York University Law School and the City University of New York Law School for a total of 30 years. I've given hundreds of law school exams and graded thousands of them. I've also written a relevant book, How to Do Your Best on Law School Exams. By initially laying out the worst way to prepare for law school exams, my intention in this first YouTube presentation is, of course, to highlight how you should frame your preparation for law school exams so that you work smart, a topic that is not typically taught in law schools, and the subject of this first presentation in a planned series entitled The Best Way to Prepare for and Get the A's on Law School Exams. My objective in this presentation, and much of my extensive writing, is to demystify law school exams, to help students break the code. The worst way, then, to prepare is just to do what you did so successfully in preparing for college exams, testing your knowledge and understanding of a subject. There, the A grades clearly go, don't you agree, to those who can demonstrate they know the most about the subject and understand the best. But in sharp contrast, the law exam A grades definitely do not go to those who just know the most and understand the best. Not at all. Rather, the A grades, and folks, this is the crux of it, the A grades go to those students who can spot the issues raised by the dense exam fact pattern and then resolve each issue triggered by those facts with a concise, lawyerly argument. That's it. The role of knowledge and understanding on law exams is to empower your issue spotting and the argument making you need to resolve each issue. Many, even most law students, prepare for an exam as they did for college exams. That college exam performance earned them good grades and got them to law school. When they begin law school, they work hard, they go to class, brief cases, take notes, and outline each course. And by exam time, they know a great deal about the appellate cases they have briefed and decoded in each subject. On the exam, they regurgitate as much as time permits of what they know that seems relevant. But alas, it doesn't work for them because law schools definitely do not give college exams. And knowledge dumps don't impress either. Indeed, professors call such dumps the vice of legal lecturing. These students did not daily practice and develop the core skills of issue spotting and lawyerly resolution of each issue that is needed to excel on the exams. In fact, just regurgitating your knowledge and even your understanding will land you in the realm of C grades that do not get you on the law review that opens a wide scope of career opportunities. The dramatic difference between college and law school exam essays is vividly illustrated by the following example. In the first year of law school, students almost always study the substantive criminal law, and I've taught it myself many times. They study its constitutional framework, its fundamental purposes and principles, and some of the important crimes and defenses, including an array of murders and manslaughters. The murders typically include intentional murder, felony murder, and extreme reckless murder. Related defenses include self-defense and defense of another. A typical college-type exam question might call upon students to compare and contrast these murders, manslaughters, and the related defenses. An A exam answer would embody knowledge, an understanding of the separate elements of these homicides and defenses, and stress the similarities and, pointedly, the differences. But in complete contrast, the typical law school exam essay problem sets forth instead a dense fact pattern and a packed page or two, detailing what I call a narrative of mayhem, of killing and defending against attacks by different parties, A against B, C against D, E against F, and so on, with a classic question at the end: what are the rights and liabilities of the parties? In criminal law, this question means which crimes and defenses are spelled out by these facts. The student then is expected to detail the issues, meaning questions about liability and defenses, raised by the fact pattern for each party, and then to resolve each issue with a concise lawyerly argument by applying the relevant rules, particular crimes and defenses. Intense time pressure adds to the challenge, usually 45 to 60 minutes. So what are your professors looking for in each essay exam argument? Knowing the grading criteria in advance directs your preparation, and students who are so prepared and can perform the critical task of issue spotting and argument making will excel. These grading criteria are: first, has the student extricated the key facts from the non-key facts in the exam fact pattern, and thereby spotted and specified the issues raised by them in light of the professor's question at the end of the fact pattern? Second, has the student selected the correct legal rules or principles to be applied to resolve the identified issues? Third, has the student applied these rules by interweaving key facts with the elements of the applicable rules? Fourth, has the student at least sometimes and appropriately utilized the policy purposes served by the application of the relevant rules? Fifth, has the student appropriately argued two or even more ways in resolving the issues that may require such two or three-way argument, given the specified facts, relevant rules, and your professor's expectations as demonstrated during the course and in her old exams? Sixth and last, has the student done all of the above with concise, time-pressured, lawyerly writing? These are the 6 grading criteria by which you will be graded. In conclusion, this presentation and the subsequent presentations to follow are designed to get you running on the right track from the beginning of the semester in each course, and to keep you off that wrong track, to get you working smart with your time and energy, to get you to frame correctly how you should and should not prepare. With the right preparation, the right framing, and a lot of hard work, you are on the road to excelling. Incidentally, the presentations are all extracted from my book, How to Do Your Best on Law School Exams. The next presentation is derived from Chapter 2 of my book, Mastery Learning for Law Exam Issue Spotting and Argument Making. You can do your best and likely excel if you prepare smart and keep at it daily. Adios and good luck.